relief. Is that right? So I wanted to make sure sometimes when it's forthcoming, there might still be tweaks. Perfect. She is also the author of a book that came out in 2018 with Cambridge titled At the Boundaries of Home Ownership, Credit Discrimination in the American State. So I highly recommend that as well. She has published numerous research articles and also many commentaries that have appeared in the Daily Beast and Monkey Cage, just to comment on a few of them. In addition to all this work and a forthcoming book, she also has a additional research project that examines the political economy of asset and wealth inequality following key civil rights reforms in the 1960s and 1970s. So with that, let's welcome her and look forward to your talk. Set a timer, just time this.
Thank you so much for coming and for the opportunity to present today. Can everybody hear me okay first? Okay. Oh, is that okay? Let's just see. Okay. It's a very high podium here, so to go on my toes. All right. So as Colleen mentioned, I am really excited to be here and to present today from my forthcoming book. It's co-authored with Emily Zakin from Johns Hopkins University from the Department of Political Science. She's not here today. And the title is The Political Development of American Debt Relief. I wanted to say a little bit about how this relates to the theme of this year's lecture series on the financialization of health, because the book isn't always exactly or specifically or precisely devoted to this theme. But it does so, I think, by asking us to think about what happens to financial burdens, including but not limited to medical expenses, when they become unpayable, right? When people have difficulty repaying. And this is an important issue and a big one, and something that we can think of in the sort of the broader framework of credit as becoming more necessary for securing basic needs in the United States, including things like housing, higher education, cars, and again, medical care. So just a few really quick things to give you a sense and to get us just thinking about debt and credit and how these things fit together. And again, I look forward to a longer discussion of this. This just shows you the sort of the increase in total debt outstanding, household debt. You can see here that mortgage debt makes up the lion's share of sort of household debt in the United States, which is almost about 18 trillion now. If you want to think about the non-housing debt balance, just because I sometimes get questions about what that includes, you see student loans, credit cards, and car loans also make up an important share. Just again, thinking more broadly and expansively about debt before I dive into the specifics of this book, we could also think about different forms of debt that are becoming ubiquitous in American life. This is one way of thinking about this. This comes from the sociologist Rachel Dwyer, who encourages us to think expansively. Things like payment plans for private medical care, rent, past due rent or utility bills are also other forms of debt. Fines and fees, maybe through the legal system or criminal justice system. In addition to, again, the sort of more traditional types of debt that we think about, credit cards, student loans, mortgages, et cetera. With that in mind, I want to talk about the book now. So I wanted to begin with this photo. This was taken nearly 20 years ago as George W. Bush signed into law the Bankruptcy Abuse Prevention and Consumer Protection Act. We refer to this as BAPA-CEPA, and BAPA-CEPA rendered the US bankruptcy code less protective of debtors in several important ways. Most importantly, it created new barriers to filing for any kind of consumer bankruptcy. Again, if we want to think about the ubiquity of credit in people's lives, we also need to think about what happens on the other side. What sorts of safety valves or levers exist when credit becomes overwhelming, when debt becomes overwhelming. BAPA-CEPA means tested the most protective form of consumer bankruptcy. This was Chapter 7 and remains Chapter 7. Chapter 7 allows people to discharge unsecured debts like credit card debt or medical bills after other assets are liquidated by bankruptcy trustees. And depending on what state you live in, some of your assets may also be shielded. And it also made it harder to retain property under the other main consumer bankruptcy chapter, Chapter 13, which was a less generous chapter to begin with, that involves people entering into repayment plans, but being able to keep certain secured assets. It was widely understood both by its critics and its proponents as a retrenchment of the sort of imperfect but still very important safety net that the federal bankruptcy code provided to householders who had found themselves with too much debt. Congress debated this bill, ultimately passed it. Obviously, we see it signed into law here. And for something, though, that mattered to so many, it was notable that only a handful of loosely organized opponents showed up to try to defend the bankruptcy code against BAPA. Now, I'm a political scientist, and so I'm interested in the politics of sort of why people showed up or didn't show up to sort of contest this act. Those who study the politics of bankruptcy, either political scientists or legal scholars, concluded that this lack of debtor advocacy at the time was a structural or maybe even an inevitable feature of the politics of debt relief. So I have here a smattering of pieces that came out in academic journals and law reviews, both in the wake of BAPA, but also in the decade ahead of beforehand where this issue was on the agenda. And you can see the different takes here about the difficulty, the inherent difficulty of mobilizing around these issues for debtors. It's virtually impossible to organize debtors. One of them says, they rarely advance their own agendas before Congress. They face unusually high collective action problems, stigma associated with publicly going out there and saying you have debt, right, and too much debt. Its potential beneficiaries do not constitute an organized and politically influential group, as Eric Posner below there says. And so these are true, especially at the end of the century, this different sort of set of possible barriers to action around issues of debt by debtors themselves. But one of the central observations of mine and Emily's book is that this wasn't always true. There's a long history of debtor mobilization that we recover here, whereby the over-indebted mobilize and press their governments at the state level and at federal level for reprieve from their debts. And indeed, governments at the federal and state levels also responded to those calls for relief. It's a pattern that may once again be ascendant too, if we think about recent movements for debt relief, especially in the field of student loan debt. And we'll come back to that at the end of this talk. But that makes it important to understand mobilization and debtor protest. So what do I mean by a long history? I wanted to start here with a textbook, like a literal textbook image, and that is the picture on the left of Shays' Rebellion. This occurred shortly after the American Revolution. Men from Western Massachusetts marched in armed regiments on courthouses. They were on their way freeing debtors from prison. They threatened violent rebellion against the state government if it continued to enforce private debts. And then the photograph on the right was taken 140 years after. And this is a picture of farmers gathered en masse in Nebraska during the Great Depression. And they're gathered there to prevent a foreclosure auction from moving forward. And so I like to put these pictures next to each other again to illustrate the long history of debtors mobilization in the US, starting after the American Revolution and continuing through the Great Depression. Over-indebted people demanded that the governments help free them from ruinous debts, and state and federal governments often responded. By the end of the 19th century, the US had one of the most generous bankruptcy systems in the world. So it was a generous system, and it was also an early mover by international standards. A network of state and local laws or state and federal laws by this time allowed debtors to discharge certain types of debts and also to protect their future income. It also allowed debtors to keep some forms and amounts of property, even if they weren't able to repay their debts. And these in turn made it so that debtors wouldn't bear the full cost of the lending relationship. So these were interventions. They could be seen in private economic bargains, collectivizing risk and protecting borrowers. And these were set in place legally at a time that many scholars until recently regarded as sort of a period where the federal government was committed to sort of laissez-faire view of contracts and of the Constitution, of what the Constitution enables with regards to bankruptcy. One thing that's notable here, again, is how early this system of economic protection developed. It long predated the New Deal and the rise of the modern welfare state, but it's also a very crucial form of early social protection, especially in a nation that relied so much on credit and debt. And again, this is why it's important when we're thinking about financialization and access to credit to think about the other side. Access to credit is sort of one side of the lending relationship. What happens to that debt, the sort of the relationship between lenders and borrowers is the other side that's important to consider. So these are the central questions for today and of the book. How were 19th century debtors able to build this protective system of debt relief, and where did they go? And why did the politics of debt relief in the 20th century up until the passage of BAPA, which I began with, look so different from the 19th? And then I'll end with a discussion about, and maybe an invitation to talk more about recent movements involving student debt and other forms of household debt. So we make three sort of main arguments in the book to sort of that work sort of in parallel, thinking about the 19th century and the 20th century. And first we emphasize that recurrent deflationary cycles, boom-bust cycles of the 19th century helped to facilitate debtor organizing. Second, that there was a regional dimension. Indebted farmers were concentrated in particular parts of the country. And third, that there was an organizational dimension. Farmers' organizations in particular embraced debt relief as a central plank of their agendas. In the 20th century, we emphasize three explanations that are very much a mirror image of the things that helped farmer debtors secure debt relief in the 19th century. First, wage earner debtors or consumer debtors got access to credit much later than farmers and in a relatively stable economic environment. This made it more difficult to learn from past crises about sort of different types of responses and demands that might be made on state or federal governments. They didn't benefit from the same political geography as agrarian debtors did. And then finally, that existing membership organizations by the 20th century that represented wage earners in various ways, including labor unions and civil rights organizations, were reluctant to embrace issues of debt relief because of sort of internal strategic dynamics that it ended up involving. So I want to start with this issue of easy access to credit. Oh no, this didn't quite. So the top says Kansas Farmer. It's just the headline of the name of the newspaper. So farmers were perennial borrowers. The source and cost of credit changed over time, but farmers generally always needed credit and always do need credit. It's kind of the nature of the industry. And historically, whether this was from local merchants, from government land offices, from mortgage bankers, or by the end of the 19th century, life insurance companies, farmers find themselves constantly in debt. So credit was necessary, but the profits that farmers were able to make were dependent on things largely outside of their control. So they had these debts that they were expected to repay, but the value of what they actually produced fluctuated and was very uncertain. Again, they were subject to boom and bust cycles. I'm wondering about this, but so farmers and organizations embraced pro-debtor politics as central elements of their platforms, and they generally took for granted the link between farming and debt. So this is from an 1889 newspaper. Like I said, it's called the Kansas Farmer. Somehow the formatting just went off a little bit. It was published in Topeka, and what it says is that the Kansas Farmer is representing the interests of the farmers of Kansas, and it does not pretend to represent any other class. A few lines down, it mentions that as between the lender and the borrower, we stand for the borrower. That worked, perfect. So this is a farmers organization newspaper from 1936, the National Union Farmer. This is from our great state of Illinois. And you can see here from this big banner headline that they're unafraid to trumpet their need for debt relief. You can note the cartoon underneath too, which sort of has the politician saying you're secure and prosperous, and the farmer saying, I don't feel that way, what do you mean? And so again, one of the things that facilitated this farmers organizing was the macroeconomic instability in the US economy up through the Great Depression. And again, as we argue in the book, this boom and bust cycle that occurs over time, this recurrent cycle, taught farmers how to prioritize debt relief. In the wake of each of these contractions, throughout this period, organized farmers demanded debt relief from their state governments. And you can see from this table that they were fairly successful. So we compiled data from state session laws, looking at sort of different economic crises over the 19th century and into the 20th century. And again, we can see the responsiveness of state government, state legislatures to the appeals of farmers. These are emergency relief laws. So these are typically things like moratoria on debt collections or on mortgage foreclosures, things like installment laws that allow debtors to repay their debts in installments over times. In other cases, some states simply passed laws to close their courts so that nobody could enforce the debts themselves. In each crisis, though, as we argue in the book, debtors remembered the previous crisis, and they frequently pointed to previous state efforts in passing debt relief laws in newspapers and sort of other forms of textual evidence to argue that legislatures should follow that sort of past lead and enact new laws. And so the practice of passing them became institutionalized, and this became a consistent feature of debtors' demand and an entrenched habit of state legislatures at this time too. In addition, as I mentioned, there's a regional dimension to debt relief, both in the 19th century and in the 20th century, although again, the logic changes. And so here's a typical statement from a Kansas newspaper. It says the West is the debtor, the East is the creditor. And what they mean here is that the people of the West are the ones in debt. This means the Midwest at the time, what we think of as the Midwest. They owe money to what they call the unrelenting and unpitying gold worshippers of the East. And this matters a lot for state politics because state legislatures in the Midwest are under immense pressure from their indebted constituents, and they respond to this pressure. Another indication here we can see are the gray states in this map are the ones that passed or renewed state emergency laws between 1860 and 1870. Just again, to give you a sense of how this looks in the sort of the regional dimensions, the black states here are not yet states at the time. This is after the Civil War. And the Southern economy at this point is in disarray. And so what we see are sort of Western, Midwestern, and Southern farmers are indebted often to Northern creditors. And so they appeal to their states to pass protective debt relief laws. Northerners begged Congress at the time to do something. And this was typical, again, of 19th century bankruptcy policies. Creditors would seek Congress's help to try to put bankruptcy policy on the national agenda, but they rarely got everything they wanted. Instead, what ended up generally ensuing was that some of the demands of these farmers in the South and in the Midwest end up also making it into law, creating a more protective set of bankruptcy policies than otherwise would have been enacted if it were just the creditors whose interests were made into law. So, and that's again because this regional dimension of debt and credit became important for national politics. So for much of the 19th century, Southern and Western states sent people to Congress who understood that they needed to represent the interests of their indebted farmers. I've cherry-picked an illustrative vote here just so that you can see it easily. And so this is a vote in the House of Representatives on an amendment on the 1898 bankruptcy bill. This became the sort of what we have as the federal bankruptcy code that persisted with modifications, but throughout the 20th century, and that we still have today, although it was significantly retrenched with BAPA. And so this was a vote in the House, like as I said, on an amendment to the bill. It would have eliminated involuntary bankruptcy, so it would have made the bill more protective of debtors. So a House member that's voting yes on this, and these are all of the yes votes, would be voting yes on sort of a debtor-friendly amendment in a debtor-friendly direction. And so this ultimately failed, but what we can see here with the debtor-friendly votes, is that they're coming from the West and they're coming from the South. There's a pretty clear regional dimension here. And then finally, on the regional politics of this, here's just a 1936 cartoon from a farmers organization newspaper that again makes it clear that farmers organizations are demanding their congressional representatives craft bankruptcy policy in the interests of debtors. It may be hot in Washington, but it's hotter back home. And we have the farmers union here, and holding up a picture of debtors protesting in front of a courthouse as sort of a reminder as to why it's important to represent these demands in Congress. Okay, so this wasn't contained to the states then. As we argue in the book, this dynamic of responsiveness at the state level and then the federal level to farmers' demands resulted in a steady rise in the debtor protective features of federal bankruptcy laws. And so here what we did was we scored major federal bankruptcy laws over time to try to capture how debtor friendly they are. And so the red voluntary bankruptcy triangles are the ones that are sort of the ones to pay attention to. The first three laws that passed were repealed relatively quickly, but each one built on and incorporated some of the sort of protective features that were sort of developed in one period. They were sort of incorporated, and what we see is a ratcheting up. This is shaded because after 1898, the bankruptcy laws no longer were repealed or sunset, but just became, yes. Oh, sorry. That is the number of what we call sort of debtor protective features in the code. So does it allow for sort of does it allow sort of exemptions of certain types of personal property, for example? So that would be a debtor protective feature. As they can sort of move up or they can go down, but it's just the number of features. It's one way of representing this. It doesn't necessarily capture sort of which of those features might be sort of more important than other ones, right? It's sort of treating them all equally. But what we want to use this to just point out is that features that were once considered new became easily incorporated into each subsequent law until 2005, when we start to see some retrenchment of this. This process starts to reverse itself, and I want to get to the 20th century now. As I mentioned, this trend of ratcheting up, of sort of increasingly generous bankruptcy provisions in the federal bankruptcy code occurs until 2005, where we see a retrenchment, and it's well understood, again, by both its proponents and opponents of being a significant retrenchment in the generosity of the bankruptcy code, as I mentioned at the beginning. And so BAPA was a markedly pro-creditor bill. It passed by a very wide margin. It had bipartisan support. And we argue in the book that this retrenchment was the culmination of a process that in some regards began in the 1980s, but in others actually is rooted in developments beginning in the 1930s, a time when more Americans were becoming wage earners, fewer on the farms. And that one consequence of that big economic shift was that by 2005, the politics of debt itself was no longer regional in quite the way it was in the 19th century. So these are the nay votes on the same bill, but just the nay votes, so that you can sort of see more easily which ones would be the debtor-friendly votes. A nay vote on this would be a debtor-friendly one. And you can see in 2005, there wasn't really a pro-debtor section of the country anymore, as you saw in the 1898 vote. By the second half of the 20th century, debt had become an increasingly large problem for wage earning or consumer borrowers, but no mass movement of wage earning debtors emerged to promote or protect debt relief policy. So when creditors, especially credit card companies, found themselves on sort of the losing end of these policies in the 1970s and 1980s, they began to mobilize. They started a large lobbying effort to render bankruptcy less protective. And there were a few debtors there to oppose this campaign. Elizabeth Warren, then a bankruptcy professor, now a senator, described the situation this way. She points out that debt relief just wasn't very high on the priority list of consumer advocates and other types of interest groups. She's talking here about the early 20th century. Again, they had other issues on their agenda. Bankruptcy wasn't really a top priority. But we argue in the book that this dynamic actually characterized much of the 20th century as well. It's always hard to demonstrate the absence of something. So we're going to try to do this. I don't know if it will be persuasive, but we've kind of tried to do this in multiple ways to triangulate. So here we examined every congressional hearing between 1950 and 2005 that had the word bankruptcy in the title. We excluded things that weren't about personal bankruptcy or consumer bankruptcy, and then we classified the witnesses that were present at those hearings. And so what you can see here is that bankruptcy experts and creditors were very well represented. And when I say bankruptcy experts, generally these are bankruptcy lawyers, sort of members of what we call the bankruptcy bar, or judges. But we see that representatives of either witnesses identifying as debtors or representatives of civil rights groups, of women's groups, of labor unions, or consumer groups only made a handful of appearances over this 55-year period. And so they're sort of on the left side, again, very underrepresented. As I mentioned before, it's hard to make the case for the absence of a movement. And I need to emphasize here that witness appearances aren't the only or necessarily the best indicator of how concerned these organizations were. You have to get invited to appear. So it's possible they were active in other ways, but maybe just not considered as relevant to these congressional hearings, and maybe that's why we don't see them. So we also looked at archival and published materials for organizations, including the NAACP, the National Organization for Women, labor unions, including the AFL-CIO and UAW from this period. And what we found there, and we document in the book, is that they also had very little discussion of debt relief. Though there was more recognition in those publications and in that correspondence and other sorts of memos about the problem of debt, even if they weren't necessarily very active in the policy of debt relief. And so, for example, in 1965, the AFL-CIO News ran this headline declaring that the #1 family financial problem was found to be over-indebtedness. So again, they recognized that this was a problem of their constituents. But despite this knowledge, unions and the AFL-CIO in particular never embraced this issue of debt relief in the way that those earlier farmers' organizations had not. In fact, when labor publications such as this one did talk about over-indebtedness, their explanations tended to focus on the individual budgeting choices of debtors and their households, rather than politicizing the problems in the ways that farmers' organizations had. And you can kind of see this. I don't know how legible this is here, but you can see the sort of emotional problems, instant comfort, keeping up with the Joneses are all kind of listed here as reasons for why over-indebtedness has become such a large problem in the lives and households of many workers. So we think that part of the explanation here is that wage earners only gained access to credit in the earlier years of the 20th century. And so this relatively stable macroeconomy of the post-New Deal period meant that labor unions didn't have the same repeated experience of deflationary crises that brought debt relief to the center of farmers' attention. It just wasn't high on their priority list because they didn't have the same periodic experience. And in fact, the economic historian and political scientist Gunnar Trumbull has demonstrated that unlike European labor movements, American labor unions themselves pursued access to credit rather than protection from creditors because they were concerned about the need to be able to sell the goods that they produced on credit. So large consumer goods, automobiles, appliances, and things like this required sort of households to take on credit, but that also produced a market for those goods and for those jobs. The other thing to note was that with this rapid rise in credit's ubiquity, access to credit, and in particular access to mainstream credit on fair terms, was itself growing into a significant civil rights issue among civil rights organizations. And people of color and married women also had a much more difficult time securing access to credit on to mainstream credit on fair terms than white male-headed households, and then the sort of the white male-headed farming households that had demanded debt relief in the 19th century. And they were much more worried about losing that access. And so the story of Julius Hobson provides an illustration of this point. So Hobson was a politician. He served on the DC City Council, on the school board. He was a well-known activist in DC in the 1960s. And in 1966, Julius Hobson, along with an attorney named William Higgs, had a plan to address the crisis of indebtedness inflicting many of his constituents. His idea was to mobilize low-income citizens in largely Black areas and largely redlined areas that were cut off from mainstream access to credit and instead faced ruinous loan terms to declare bankruptcy en masse. And so he circulated a manifesto to Black power advocates. And in that manifesto, he described the existence of a set of laws enacted during the populist period to free the poor from oppressive debt imposed on them through usury and exploitation by the rich. He's talking about the bankruptcy laws. And he's saying here that they've not been used enough by, quote, America's poor Black people who remain largely ignorant of this powerful self-help weapon within their reach. So like the movement of the 19th century white debtors that he invoked, Hobson rejected stigma associated with over-indebtedness. He argued that powerful banking, industrial, and political interests had created a self-serving stigma around debt, that associated shame was engineered to stop his constituents from recognizing that they too could use what was already existing law to protect themselves. So this is a good point to stop and remind everyone that Hobson was merely advocating that eligible consumer debtors use the existing bankruptcy statute. He's not actually calling for anything new here. And yet at the same time, this message was met with resounding outrage and universal rejection. The Philadelphia Inquirer described it as a firebrand scheme. The Tulsa Tribune warned that this would undermine the growing Black middle class, even if it produced some benefits for a few. Even the potential participants that Hobson and Higgs tried to enlist were horrified at this proposal. So when Hobson wrote to the Scholarship, Education, and Defense Fund for Racial Equality to help him publicize this plan, he gets this letter back. Essentially, they say no thank you, but they go on to explain why they are concerned that too much debt relief would ultimately undermine their efforts to promote credit. And so you can see here the filing of mass petitions would eventually lead to the termination of this system. It would contribute greatly to the end of credit in low-income areas. This denial might work to an insurmountable hardship of many of the people who are forced to live in this manner. There's no doubt that this result would be undesirable. And so the idea here is that debt relief makes credit more expensive. Seems about right? And this is one of the explanations that we provided earlier too. When loans become riskier for lenders, when the law might simply deprive them of repayment, lenders price that risk into the future, or they just stop lending altogether. And so that is the concern that's laid out here. And indeed, many scholars offer this tension between easy debt relief and available credit as an explanation for why debtors don't organize. In other words, that cleavage is really between those who want more access to credit and those who prioritize debt relief. That's what prevents debtors from having much political voice. So what we describe in the book is how that sort of tension ends up playing out in the civil rights politics of debt relief and credit access at the time. It creates the second half of the 20th century in many ways is a golden age of citizen-based movement politics. But it's difficult for debt relief to emerge as an issue when at the very same time the issue of credit access is also something that's being pursued and being pushed by members who are also being marginalized from the credit system. So it creates a sort of strategic dilemma for many civil rights organizations that are very active in pushing for access to credit, but struggle to help their constituents deal with potential downside consequences, even as they recognize internally that those exist as well. So in the 1960s and 70s, the unsecured creditors who stood to lose the most from debtor protections weren't particularly well organized around bankruptcy policy, and this is sort of the last part of this organization's answer or explanation. And this also starts to change after the Supreme Court issues several decisions, but importantly, the 1978 Marquette decision that freed lenders from the constraints of state usury laws. At the same time that this had happened, computerized credit scoring became possible, and it became possible to use this at scale. And so those two developments paved the way for the explosive growth of the credit card industry, and also raised the stakes of inaction and sort of the lack of organization of the consumer credit lobby in the sort of earlier part of the 20th century. So consumer lenders found themselves on sort of the fighting side of bankruptcy by the 1980s and into the 1990s and 2000s. Here is Elizabeth Warren testifying on C-SPAN about the need for protective bankruptcy laws. You already know she feels like it doesn't really have any popular support among the people who would be the most likely to benefit. And what we show in the book is that with no grassroots movement to defend it, this debtor-friendly bankruptcy statute became vulnerable to attack, and ultimately it became retrenched in 2005. So we end the book with the observation that we've seen a resurgence, or perhaps a faint echo, of the debtor protests that characterized the 19th century. We've seen that in the wake of multiple 21st century crises, the financial crisis of 2008, COVID-19, to some extent the sort of role that Black Lives Matter played in bringing issues of the Black and white wealth gap and also sort of inequalities in student debt holding to the fore. And we've started to see similar types of tactics too, efforts to disrupt foreclosure hearings, efforts to challenge the stigma associated with debt by grassroots organizations again. We have a few examples here. There's an anti-eviction and foreclosure protest. Here is an organization called Strike Debt that became the Debt Collective, which is still active now and has been credited with being sort of one of the main drivers of bringing student debt relief to President Biden's policy agenda and campaign. This was an earlier demonstration that they had staged during Occupy Wall Street. Someone's crushed under a boulder of student debt and housing debt. And we also see efforts at sort of local level. LA County here is